right, welcome everybody. We appreciate you joining us both live and in person here in Miami and remotely via Zoom. My name is Charles Throckmorton. I'm joined here by my partner, Aaron Weiss. We are both litigators here in the Miami office of Carlton Fields. We appreciate everybody joining us here and remotely via Zoom. If you have any tech issues or if we're not coming through, just please let us know in the chat and we'll do what we can to address that. So I'm going to go ahead and get us started here with a summary of what we're going to be talking about today, sort of a roadmap and a preview. We will start with an introduction, a discussion of the Federal Arbitration Act, what it is, why it is, where we're going. Then we will discuss 5 recent Supreme Court decisions from between March and June of this year that relate to arbitration. We will then quickly discuss the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, followed by the second half of our program will be focused kind of on practical pointers, recent trends, mass arbitrations, a discussion of a Northern District of California District Court case that implicates the language that parties should or should not use in their arbitration provisions. And then at the end, we will have time, hopefully, for questions and answers. We can take questions live here in Miami. And I also understand that there is a Q&A button or function on the Zoom. So if you have questions as we go, please put them in the Q&A box and we will do our best to address them either as we go or at the end. So that's what we're going to be doing today. With that said, I'm going to move us to the next slide and turn it over to my partner, Aaron.
Well, thank you, Charles. Now, I have had occasion to frequently talk about arbitration in settings like this or just around the water cooler. And it's always important to me to keep in mind there's a very long tradition of arbitration in the United States. And whenever I sort of talk about arbitration, this particular slide that I have up is something that I like to sort of put up to frame the issue. And this comes from a particular contract where it says, all disputes shall be decided by 3 impartial and intelligent men, known for their probity and good understanding, 2 to be chosen by the disputants, each having the choice 1 and the third by those 2. And then those 3 men can enter a decision that is to all intents and purposes to be binding on the parties. So I always ask people, and I read this sounds like, some of the language may be a little flowery and not modern. And I don't know if a modern contract would restrict it to only men being arbitrators. But the curious question is, where is this from? And where is this from, Charles?
Our next slide.
This is from the will of George Washington. So over 220 years ago, George Washington put into his own will that if there were a dispute over divvying up his assets, it would go to arbitration. This is in the 1790s. So I like to think about that the whole notion of arbitration is not something that came about yesterday. It has been a long tradition in the United States. However, and I also like to think about George Washington in this regard, the 7th Amendment of the United States Constitution provides for jury trials in all civil disputes where more than $20 is an issue. And I think the last time I checked, the $20 an issue from 1787 was about $3,000, although I checked that a couple of weeks ago, so it may be worth $6,000 now with inflation, but who knows? So there's a tension, the long tradition of arbitration, yet when the founding fathers sat around the table in Philadelphia, they decided that we're going to have jury trials. So what happens? Well, particularly in the early 20th century, so the early 1900s, the notion of arbitration started to become more commonplace. So we have this tradition where people can agree to it. We have, as I said, George Washington did it in his own will. But now, starting in the early 20th century, this is starting to become something that becomes more commonplace. And I will tell you, to go back to your high school civics class and high school history, named Samuel Gompers is a name I remembered when Charles and I were talking about this last night. And Samuel Gompers was one of the leaders of the American labor movement. And a lot of the notion of arbitration and the tension in arbitration in the early 20th century came about in how the courts would decide to deal with arbitration in these labor cases. So there's a big tension now. In 1925, during the administration of Calvin Coolidge, this is how long ago it is, Mr. We could use a man like Calvin Coolidge again. The Supreme Court, the Congress and the president signs into law the Federal Arbitration Act. So against the tension from the labor movement that I was talking about with Samuel Gompers and his cohorts, and some courts really having a hostility towards enforcing any arbitration agreements, Congress stepped in and said, we're going to have a federal statute and make the, sort of the legislative framework to put arbitration agreements on an even footing and make them enforceable. So really, by that time, 97 years ago, 1925, that heralded a new movement and a new thinking about, arbitration now maybe a viable thing. And the federal courts were going to use their supremacy clause, put a statute into place. So basically, and the exact language is, to ensure arguments were valid, irrevocable, and enforceable, save upon grounds as existed law or inequity for the revocation of any contract. The point was, in 1925, in the shadow of there being real hostility, particularly in state courts, but some federal courts as well, of being hostility to arbitration. And really in any type of things, a lot of these were business to business things or these labor disputes. We're going to talk a lot about consumer arbitration. That isn't something, the notion of arbitrations with consumers, that's really where a lot of the action is today. That didn't really come into play until a few decades later. But really the framework is up until the Federal Arbitration Act in 1925, for several decades, there was really a lot of hostility towards these things. But 1925, we put the Arbitration Act in place. And in the past, particularly the past, I'd say 2 decades, we have had a ton of litigation on the Arbitration Act. So much so that what happened last term, Charles?
So this is why we're here, or getting closer to why we're here. In the last Supreme Court term, specifically between March and June of this year, the Supreme Court issued 5 decisions that relate directly or indirectly to arbitration. That's a lot. And we will discuss the 5 cases that you can see on the screen now. There's a little bit of a preview about what they're about on the screen. And once we're done talking about them, we'll talk about, whether or not this is indicative of a new trend, a new attitude, what the key takeaways are. So we'll go ahead and get started with the first case, which is Badgerow versus Walters. You can see on the screen here the stats. This is decided March 31st of this year. It was an 8-1 decision with Justice Kagan authoring the majority opinion and Justice Breyer dissenting. In a nutshell, the issue in this case was determining how a federal court assesses its own jurisdiction to hear, whether it can hear a motion to vacate or confirm an arbitration award under sections 9 and 10 of the FAA. In other words, what is the court allowed to look at to determine whether it has jurisdiction? And, getting to the end here, the holding is that the quote look-through approach, which was prevalent in some circuits used by many courts, which had allowed a court to look beyond the petition to confirm or vacate the award and down into the underlying dispute to see, was there a federal question? Was there diversity between the parties in the arbitration? You're no longer allowed to do that. The law of the land now, following Badgerow, is that a federal court, in assessing whether it has jurisdiction to entertain a motion to confirm or vacate an arbitration award, can only look at the face of the petition and may not, quote, look through to the underlying dispute. So, one of the takeaways here, one of the practical implications here is that it is now less likely that a federal court will have jurisdiction to vacate or to confirm an arbitration award. So by default, that means that more motions will be heard and decided by state courts. In reaching this decision, it's a well-reasoned decision, and it goes through a lot of the history here. But one of the conclusions reached by the court was that the FAA itself, as Aaron described, we understand why it was enacted, but it in and of itself is not a standalone basis for federal jurisdiction. A court must have, independently have either diversity or federal question jurisdiction. Just because there's a motion pursuant to a provision of the FAA doesn't mean that the court has jurisdiction.
Right. So I think this is a really interesting case. It's kind of a wonky thing. And I always have clients tell me, well, the last thing I ever want to fight about is the venue for my case. I want to get down and dirty and just, fight over the merits of the case. And now, if that's the last thing that you want to do, the super last thing that you want to do is to, win your case. You've gone through arbitration, and now you're fighting over where you go to enforce your arbitration award. And this concept is, it actually does come up a lot in just regular litigation. And a lot of people, I've seen people trip over this a lot. This is the concept of, let's step away from arbitration for a moment. And if you have a settlement and the parties have a settlement, and let's say that it was an antitrust dispute. So clearly, under the Sherman Antitrust Act, there's a federal question. The case is in federal court. And now the settlement of the antitrust case is, that the plaintiff will, the defendant rather, will pay the plaintiff $50,000. And there's a settlement, and all dismiss all the claims. Well, in regular litigation, that is something that, unless you tell the court, the court will, and ask the court, and the court agrees to reserve jurisdiction. That scenario that we just described, the court, the federal court, would not have jurisdiction because there's not a sufficient amount in controversy. And, it's not a federal question. It's just a breach of an obligation to pay $50,000. So what happens is that concept is really at the heart of the Badgerow decision. And what the Badgerow decision essentially says, Charles, the key takeaways are.
Right. The key takeaway is, when a court is now looking at whether it has jurisdiction to vacate or confirm an award, it has to be apparent on the face of the petition. You're not looking at federal question. You're not looking at the diversity of the parties necessarily in the underlying dispute. And so we have two examples here of fact patterns that may come up now and would be decided in a different fashion post Badgerow. So example one, a motion to confirm a $50,000 award entered for a Nevada claimant against a Florida respondent. You have diversity of the parties, but you don't have amount in controversy. Example two, a motion to confirm a $200,000 TCPA judgment.
That's a federal statute.
The Telephone Consumer Protection Act, entered for a Florida claimant against a Florida respondent. Here you have the amount in controversy and you have a federal question, but you don't have diversity. And because the court isn't looking at whether there was a federal question in the underlying arbitration, you don't have jurisdiction to vacate or confirm that award post Badgerow, and that would be a question for a state court to decide.
Right. So Charles, that's probably a good time. These examples sort of remind me, we'll go through a lot of what we're talking about today is just sort of summarizing some Supreme Court decisions. But as whenever we do one of these presentations, it is always good to remind these are not the views of our clients. And particularly whenever I do a presentation, people always have to tell me that these are Aaron's views only. They're not the view of Carlton Fields, because sometimes people tell me my views are different than other people. But so these examples are, this is how Charles and I think some of these cases could come out after the Supreme Court cases that we're going to talk about. Now, one of the things that is really significant to me in this Badgerow situation, in the after Badgerow, a lot of times in an arbitration, the defendant, who's called the respondent typically in arbitration, will win. And in court, in state court or federal court, you would say, well, they got a take nothing judgment. In other words, judgment is entered in the favor of the defendant. The plaintiff shall take nothing. In Florida, we say the defendant shall go hence without day. And if you email me, I could tell you the whole story behind that, but it'll take me too long to get through here why they use that language. Anyhow, in an arbitration, if the respondent, again, the defendant in the arbitration wins, they get an award. And it says the arbitrator awards the plaintiff nothing. And the defendant, can leave. Let's assume there's not, shifting attorney's fees or whatever. The defendant has an arbitration award. They've said they've won. The plaintiff, who's called the petitioner in the arbitration, gets nothing. And now the defendant, the party who won, says, great, I won. I want to get this on file. I want to be able to have what they call res judicata, so I don't have to litigate this again. Well, what do? It does seem under Badgerow that they have to go to state court, no matter what the original, could have been an arbitration where the plaintiff was seeking $50 million and the parties are diverse, or the statutory basis of the arbitration was a federal claim. But now keep under Badgerow, all it is, it's an award for the defendant, and the plaintiff gets nothing. So you're not going to have amount in controversy. That's just going to be a regular dispute. And what Badgerow does seem is the place that you're going to have to go, and the defendant to enforce that now is going to be state court. And Charles, I want to, before we leave Badgerow, there's just one, if you go back the other direction, I don't want to leave without just for a minute talking about Vaden, because Vaden is the other side. Vaden is a case that was decided about 13 years ago. And that's the difference. So the last thing I want is somebody to sit through this presentation and say, well, hold on a second. I thought those guys from Carlton Fields said, I don't have jurisdiction in arbitration or to bring an arbitration proceeding to enforce it or whatever in federal court. Well, Vaden's a little different because Vaden talks about a different section of the Federal Arbitration Act. And what Vaden talks about is it's the other side where there's a lawsuit and one of the sides wants to compel arbitration. In that situation, just because it's literally the language of Section 4, which talks about the front end trying to get to arbitration, has different language than Sections 9 and 10, which is the back end, that what do you do after you've been through arbitration. So Vaden, you do have the look through. And by the way, what happened, the party who was trying to use the look through in Badgerow was basically said to the court, look, you've already said you got to look through this. And it wasn't that long ago. It was in Vaden. That was only 13 years ago. Take that look through concept and use it on the back end. And an 8-1 majority of the court said no. And it's a little telling. The one justice who would have gone to the look through, sort of what you would call the purposivist approach, was Justice Breyer. Is one of the last cases that he sat on, who historically Justice Breyer was known as more of a purposivist judge, where a lot of the other judges sort of on both sides have now gone to this strict, we're going to look at what the statute says, look at the exact words of each section and apply it come what may. And here the court, the 8-1 majority, noted that there is a difference in the language in Section 4, which is the front end, as opposed to Sections 9 and 10, which is the back end. So that's all I have to say about Badgerow, but I could probably keep talking, but we've got 4 other cases to go through.
We've got other things to talk about. So we'll move to the second case now, which is Morgan versus Sundance. decided in May of this year, a unanimous decision with the opinion authored by Justice Kagan. In a nutshell, the question was, if you are arguing that I guess often the defendant in a case has waived its right to compel arbitration. It used to be the case in most circuits that you had to show that you were prejudiced by the conduct of the defendants that you said would effectuate a waiver. The Supreme Court has now resolved the circuit split and essentially said that prejudice is no longer a factor that should be considered in the waiver analysis. So this is one where we'll get into the facts a little bit. As a litigator, Aaron and I both litigate issues like this. I think a lot of people joining us live and remotely probably do as well. The facts of this case give me a little bit of heartburn. So let me go through them quickly. The plaintiff was an hourly restaurant employee who filed a nationwide collective action alleging that the defendant had failed to pay overtime that was owed to a broad class of its employees. Because there was an arbitration agreement in the employment or arbitration clause in the employment agreement, the plaintiff and the entire class arguably should have been subject to arbitration. But instead of immediately moving to compel arbitration, the defendant waited. And not only did they wait, they took affirmative action, aggressive action in litigating the case. They moved to dismiss, it didn't succeed. They answered the complaint, and then they scheduled and attended the mediation. This process took 8 months from the filing of the complaint through to the unsuccessful mediation. And at no point during that time period did the defendant raise the arbitration issue. Only after the mediation failed did the defendant then move to compel arbitration.
Right. And just keep in mind, the scenario that Charles talked about, that happens to be, I guess, in an employment case, you call it a collective action, and similar type thing could have been a class action. This isn't a decision. The point here is not restricted to just class or collective actions. The same type of analysis is in sort of a B2B, a business to business arbitration dispute as well. So I think that's important to remember about Morgan.
Right. And so as far as the procedure, the trial court denied the motion to compel arbitration and found that this 8-month delay was unreasonable and had prejudiced the plaintiff, who had to defend against the motion to dismiss, go to the mediation, engage in the litigation before the district court. The 8th Circuit reversed and again looked at this prejudice issue and said that the plaintiff was not prejudiced because they hadn't gone through discovery. They found that there had been no duplication of work during this 8-month period. And so the question for both the trial and the appellate court was there prejudice?
Right.
I mean, clearly there was a delay. Clearly there were actions that were taken by the defendant, but was there prejudice? And it was this extra prejudice factor that made its way up to the Supreme Court, which had to decide a circuit split here, because almost every circuit, you can see the list here, including the 11th Circuit, where a lot of us in this room regularly practice, had said that, yes, you have to show prejudice in order for there to be a waiver. But the DC Circuit and the 7th Circuit said you didn't. The Supreme Court has now come out with the Morgan case and has said that prejudice is not required to find a waiver. So this is a decision that is not arbitration friendly. It signals, we think, maybe a trend away from preferential treatment of arbitration, deference to arbitration, presumptions in favor of arbitration. And as the court put it, the FAA, which we've talked about, was never intended to create this presumption or preference or encourage arbitration, but rather to make sure that arbitration agreements are placed on, quote, equal footing with other contracts.
Right. And just to put a fine point on the prejudice, what the Supreme Court is saying is there is no arbitration specific created by the U.S. Congress under the Arbitration Act in 1925 or emanating from the Arbitration Act prejudice requirement. You may have a state law rule, in that case it was Iowa, that says in order to prove waiver of any right under a contract, you have to prove prejudice. And what the Supreme Court essentially says, if that's true, if the particular state law rule would require prejudice to show waiver of any contractual right, that's different. But that would come from a state law rule. And the Supreme Court remands the case to the Eighth Circuit and presumably then perhaps down to the court in Iowa, Southern District of Iowa, or maybe to the Iowa Supreme Court to opine on what Iowa law would say. The Supreme Court doesn't answer questions about what a state law would rule. At least they haven't done that since Erie in 1938. So that's what the important, the waiver specific question in Morgan. But as Charles said, the bigger issue to me in Morgan is really just absolutely putting a real, further path away from this notion of the presumption of arbitration. That used to be going back, for decades. There's been statements in Supreme Court cases about the presumption of arbitration. And I can tell you, I've done a lot of cases for defendants and practicing for 20 years. And always see, whenever we're trying to get to arbitration, there's a presumption of arbitration. And what the Supreme Court has said now a couple times in the last few years is they've really pushed back and limited where that presumption comes into play. And what we're really looking at, what's left, is the presumption, to me, that will remain is the presumption of, is a particular dispute under the contract. If it's a close call, you may have contractual language that says, we will go to arbitration for any disputes arising from the contract. And the parties are in a dispute, and it's a question of whether the particular dispute arises from the contract. That's where you still probably have the presumption. Right. But if it's for these other things, like was arbitration waived, or you'll see with our next case, we're going to talk about another one, that's where it is really pushed back. And then the other thing. Yeah.
The other takeaway here for me is don't wait. If you have an arbitration defense, if you have a motion to compel that is viable and in good faith, file it, don't wait. Because now certainly in the 11th, across the country and in most circuits, you no longer have an added buffer. You no longer have the argument to make that, yes, we waited, but it was harmless. It didn't prejudice the plaintiff. That's not available anymore. So, don't wait is my takeaway. And I'll give you, and then I promise we'll move on. And I know the one I'm going to get in trouble for, and maybe somebody will quote back to me. If you have, maybe I'll ask Charles, I've probably asked him this hypothetical. If you have a defendant who is sued in a small claims court for $50 for, some very, whatever the case is, and they're sued in Miami-Dade County Small Claims Court. And they know there's a contract and it has an arbitration clause. What should they do? I'm going to let you answer that your own hypothetical, Aaron. Well, the answer is, I don't know. I mean, this one really, that's really troubled me, that when you have a situation and you have an arbitration clause, that's the part of Morgan that has given me the most heartburn for these potential, little small claims cases. And because, you could have it amended and become a class action and who knows. So, but nobody's done that so far that I'm aware of. So I guess we'll see what happens. So now we'll move on to our third case. This is the Southwest Airlines versus Saxon case, decided in June of this year. Unanimous 8-0 opinion, with the opinion issued by Justice Thomas and Justice Barrett not joining. This is a little bit of a nuanced holding that to me applies more to an industry than to a litigants nationwide or to attorneys, but we'll talk about it briefly. The holding here, the question was, is someone who supervises the loading and unloading of planes at an airport and at times engages in the unloading and loading herself, is that person part of a, quote, class of workers engaged in foreign or interstate commerce and therefore exempt from arbitration under the FAA? And the holding in this case is that yes, although it was heavily contested and it's a nuanced decision, the facts are that this person who was loading and unloading an airplane is deemed to be engaged in foreign or interstate commerce. So getting into the facts, we'll try to go through this pretty quickly. As I said, it was a ramp supervisor for Southwest Airlines operating out of Midway in Chicago. She supervised the loading and unloading, and at times herself loaded and unloaded planes. Like in the Morgan case, this was an FLSA, Fair Labor Standards Act claim. Like in the Morgan case, there was an arbitration provision. Southwest moved to compel arbitration. And in this case, the argument was that you cannot force me to arbitration because I am a member of a class of workers that is exempt under Section 1 of the FAA. And the question was, do I, as someone who works at an airport, I'm not getting on the plane, I'm not flying the plane, I'm not driving a bus across state lines, I'm not riding the train across state lines, I work in the same place every day, but I am loading and unloading cargo that flies around the country across state lines. Do I qualify? There was a circuit split on this issue. The split was, do you actually have to be involved in the transportation? Like I said, you have to be on the plane, or the other examples, or is it enough to be involved in the acts leading up to it? And the holding here was that in this instance, with the loading and unloading of planes, that was enough. That's a close enough nexus. The quote here, these workers play a direct and necessary role in the free flow of goods. That was the analysis. That's the decision here. It's worth noting that the plaintiff argued for a very broad definition of this provision. And they wanted to argue that literally every single Southwest Airlines employee, desk job, airport job, anything, anywhere, was engaged in interstate commerce just by virtue of being a member of the industry. And the Supreme Court, you can see it, it's the last bullet point here, rejected that approach. And in doing so, consistent with this decision in Morgan, I don't know if it's surprising or not, I'll leave that to Aaron, but took a position that the FAA does, there's no pro arbitration, favoring arbitration reason to expand that to include anyone involved in the industry.
Right. So this, I don't know, Southwest Airlines case is it's an interesting history lesson. Basically what happened when the Federal Arbitration Act was passed in 1925, there had been a Arbitration Act that was related to railway workers and seamen a few years before. So the reason why that category of workers gets exempted, the transportation type workers, from the Federal Arbitration Act, is because they had their own separate Arbitration Act. Now fast forward 100 years and we have the gig economy and just a lot more transportation, and I don't know, it was 1922. When was the Wright brothers? 1907. So I don't know what kind of commercial airlines you had in 1922. But imagine if the Wright brothers looked at Southwest Airlines, they wouldn't recognize it. So it's a lot different. What you've seen in the last few years in trying to stretch the Section 2 exemption, it comes up a lot in the gig economy, the Ubers and that type of stuff. It's really, where are we going to draw the line for these people who may have some transportation? So the real couple core questions are they engaging in transportation, number one, and then are they engaging in interstate commerce? So this case, Southwest Airlines, if you're involved in an airline, it's by definition, I think it's interstate commerce. It's regulated under the other FAA, the Federal Aviation Administration. So there's actually two FAAs in the country. But the interstate commerce one's interesting. It's not in this case, but a couple of the cases that have dealt with this exemption. There's some interesting case law. I think there's like a Third Circuit case and maybe a Ninth Circuit case. It was off the top of my head. I promise is full of my prep about, like Uber type drivers who may periodically pick up people, from Newark Airport, and maybe 1 in 100 people they pick up, they drive to, New York or Connecticut. It's probably more at Newark Airport, but imagine I don't know, if you're at the Jacksonville Airport in Duval County, maybe 1 in 100 people who you pick up at the Duval Airport, you drive over to Georgia. So that's probably a good example. So that's sort of like the question of where's the line. And so that's what's going to be left. And not a ton that's sort of trans-substantive other than that. But yes, other than, of course, as Charles said, it's another case where the defendant advocated for that, the overriding pro arbitration and purpose, and the Supreme Court rejected that. So that's Southwest. Interesting case, kind of confined to the facts of transportation. So the next one, I'm going to go through this one quickly, I promise, because it's pretty California specific, but it's sort of an interesting case. There's a case called Viking River Cruises called Moriana. It is a weird 5-4 decision, sort of. The majority opinion is by Justice Alito. There's concurrences by Justice Sotomayor and Barrett. Then there's a dissent that's Justice Kavanaugh, Justice Roberts, and I think Justice Gorsuch, maybe. And then Justice Thomas dissents, because Justice Thomas historically dissents in cases that come from state courts, because he has a position that the Arbitration Act the Federal Arbitration Act shouldn't apply in cases that come from state courts, but he's the only justice who generally takes that position. So to try to keep this super simple, there's a California statute called the Private Attorney General Statute. And basically what it does is it allows a plaintiff in California to bring a lawsuit for, wage and hour type violations. And they could sue a company for the violations that have happened to them. And then also sort of standing in the shoes of the California Attorney General can also seek damages for the other wage and hour violations. So it's not really like a class action. It's sort of this sui generis procedure that California has. So it gets really complicated, and it hurts my head to try to keep this straight. But basically, what the defendant tried to say is, well, this PAGA claim is really a representative action. So you have an arbitration clause that says you can't bring a representative action in arbitration, but you have the same arbitration clause says if you sue us, you have to sue us. The claim has to be in arbitration. So the question is, well, where does that leave it? At the oral argument, the Supreme Court, questioned that and said, isn't that a catch-22? I will tell you, and they had a very, very accomplished attorney arguing for the defendant, or I don't know which side. I guess, they were the petitioner, the company. But in some ways, it came down to like the argument was, well, them's the breaks, meaning, where do you leave it? And the Supreme Court really seemed to have a bit of a problem with that. So I think you could characterize the decision as the Supreme Court sort of largely punted, but basically said, look, if you have this individual claim, this PAGA claim, you have, California at least said you have a right to bring a case for these wage and hour violations. And we can't take that away from you. So you could bring that, if there's an arbitration clause, presumably in arbitration, and we'll leave up to the rest of California, how to sort out where that leaves the rest of the claim. But we're not going to, those claims can't be in arbitration. So it's a bit of a punt, but they did say, no, you can't bring these PAGA claims in arbitration on behalf of the other people in arbitration. You can't bring them in state court, or federal court, but at least, we're not going to cut off your individual claim. I think that's Viking River Cruises. Again, a lot of it because of the way they punted and left it down to California. There's not much left other than to say, but I think there's a couple big, broader takeaways from Viking River that I would suggest are, do we have a slide on that, Charles?
We have a slide at the end, where we'll talk about some of the big picture takeaways from all of these. So let me segue us into the last Supreme Court case. This is ZF Automotive versus Luxshare, decided again in June of this year. Unanimous decision with the opinion authored by Justice Barrett. This case looked at I don't know if this is a sparingly used tool, but doesn't, it's not applicable to everybody. It's a litigation tool that is available under 28 USC 1782. And in a very rough nutshell, what that statute does is it allows a litigant before a foreign tribunal to use the United States district courts to seek discovery in aid of the foreign proceeding. And so there had been a circuit split about what does it mean to be what are the definitions of a foreign proceeding? What types of foreign proceedings can you use this tool to get the United States discovery for?
Right. And just to pause a bit, Charles, because I think when we talk about this case, it is really interesting to think about 1782. I know we're talking about arbitration, but maybe if if the one thing you take away is now I know about 1782, it's one of these statutes that I always tell people that the first time you encounter it, you read that and you hear about that, and like the almost uniform reaction is, no, that can't be right. You mean that? So like in Germany, I'm just making up Germany, where I'm not entitled to any civil discovery for anything. I have a dispute with you could have a divorce in Germany. Husband is suing a wife for divorce in Germany and may not be entitled to any civil discovery. And don't use Germany and say that that's really what's in Germany. I'm literally just making that up. But under 1782, you could come to the U.S. court and say, well, the wife has a bank account and she's a partner in some business in Iowa, and she has a membership interest in some LLC in Nebraska. And you could get all that discovery, even though you wouldn't be able to get it in the home forum. It really is, as I said, the first time you look at this, you really think that can't be right. But that's what the U.S. Supreme Court has said. They had a case called Intel a few years ago. The rationale is that, and why the U.S. courts have countenanced a broad interpretation of 1782. It's presumably supposed to be for comedy that, in the U.S. we have pretty broad litigation. So if our U.S. citizens are involved in disputes overseas, we want the overseas forums to give comedy to our citizens and allow them access to discovery. Well, the bottom line is it ain't happening. In practice, most forums overseas are still taking, if their home forum has a narrow view of discovery, they follow it. So the ZF Automotive case is, okay, well, does 1782, how far does 1782 apply when the foreign dispute, the international dispute, it's not, sort of the husband suing the wife and they're in the court in Dusseldorf. This is if they're in an arbitration in Bonn.
Right. And
or
so,
Dusseldorf.
right. And so I think you had Germany on the brain because this case involved a German arbitration proceeding. So the facts are up on the screen now. I'm not going to go too deep into them, but it was a business to business dispute where the purchase agreement required arbitration in Germany under the rules of the German Arbitration Institute. Luxshare, the claimant, tried to use this American discovery tool to obtain discovery in American district court to help them in this German arbitration. And this is where I think the importance of this is, as litigators who practice in district courts in the United States and who may have international arbitrations, the question is, can you still use this for an international arbitration, or does it have to be something else? And the holding is that only a governmental or intergovernmental adjudicative body qualifies for this procedural tool under 1782. So in this case, this German arbitral body was not deemed to be governmental, and therefore 1782 is not available. So this holding also applies to international arbitrations,
Right.
which I think was where this was such a useful tool, and it no longer is. So
Right.
to me, that's the takeaway here. I think it really is more of a practical takeaway that we as litigators have lost a very powerful tool, which has been narrowed.
Yeah, and it absolutely is something that would come up a lot. So, and just to cheat a little bit, there technically was a companion case to that. I didn't even want to make a separate slide. It's called Allocate Partners. That case was the issue in Allocate Partners was so specific to whether a particular forum was one of these governmental, foreign or international tribunals. I didn't want to get too far in the weeds on that because it's so specific. But the 1782 thing, I mean, it actually does come up a lot. these 1782 cases. And we're in Miami, Charles and I, and because you have a lot of international commerce here, it really does come up. But the fact that that is now not on the table for arbitration is going to make a practical difference for people involved in international arbitrations.
Right. So the next slide, we're now done talking about these individual cases and want to try to give some overview, our take on what big picture trends, or whether you can take away some attitude shifts from this term. Is the current makeup of the court and these decisions, are they indicative of some future trends? And so we have some bullet points here.
Right. So this is, as I said, this is if you're, at a cocktail party with a bunch of lawyers and somebody says, well, how about that Supreme Court? And you don't want to have an awkward conversation, maybe about some hot button issue. You're not going to say, whatever that may be. You say, yeah, that Badgerow case, that was a humdinger. So, some of our takeaways. Well, Morgan and Southwest, if there's a through line, is that this uniform preference for arbitration has really been challenged. As I said, I think it, will really, where it will have its remaining, impact is in the arbitrability question. But what often happens with the arbitrability question is in many arbitration clauses, both commercial and consumer cases, the arbitration agreement will delegate that question of arbitrability to the arbitrator. So that, that might not even come up. Viking River, again, the case that I said my head hurts on. I think what you see with Viking River, there's a through line now in cases coming from the California courts over about the last 10 to 15 years, where whatever sort of, Rube Goldberg contraption that the California courts were coming up with to try to avoid the impact of the Federal Arbitration Act, sort of one after another, really going back to a case called AT&T versus Concepcion, over a decade ago. The Supreme Court has, shot down those remedies. And then Badgerow and ZF Automotive, I think those are good examples of strict statutory construction cases. The outcomes in those seem to, in the end, if you read the opinions, the outcomes from those really do seem to be dictated by what the language of the statute says rather than some overarching policy concerns. So I'm sure we will continue every term to see a lot of arbitration cases. They're not stopping. Even so some of the questions on Southwest that were punted, some of the questions on Viking River that were punted, and there's a whole bunch of other ones as well. So I expect, I know there's a couple on this term, but yeah, usually every term you get a couple. This was unusual. I guess counting Alix Partners, which we didn't have a separate slide on. I think there were 6 out of, I think it was roughly in the high 50s. It depends on exactly how you count, of the cases that the Supreme Court decided, after full briefing and argument last term, were arbitration cases. So that's a lot, like 10% of their docket were Federal Arbitration Act cases. So as I said, if nothing else, you now have something to talk about at your next cocktail party.
Leave it up to you all to decide whether that's a wise icebreaker at a cocktail party. So now we're going to move on to a different topic, which is, you probably saw this in the news. If you are lawyers, you definitely saw it in the news. This was a recent March of 2022 act that amended the FAA. And Aaron, I'll run through this quickly, and essentially made it so that it is no longer legal to force a victim or someone who has a sexual assault or sexual harassment claim into arbitration. As it says in the slide, this applies to past and future agreements, but only to claims or disputes arising or accruing after the effective date of the amendment, March 3rd, 2022. The decision as to whether to arbitrate is now placed in the hands of the claimant. And I think one of the key takeaways at the time was, what does this mean for arbitration writ large?
Right. So, look, everybody who follows the news, we're not, commentators on current events, but you could have followed the news over the last 5 years, and this was an issue that would come up in the news, this concept of forced secret arbitrations, these confidential proceedings of these, the sexual harassment and sexual assault claims. And it seemed to be criticism from a lot of sides of the political spectrum on that. There had been, and there have been, efforts to reform the Federal Arbitration Act writ large for about the last 15 years. That AT&T versus Concepcion case was really what was at the heart of that. There have been, some senators have been very proactive about that. Senator Klobuchar in particular has been at the forefront of that. On the other hand, or related to, let me rephrase that, one of the arguments for a larger reform of the Federal Arbitration Act was this concept of the Federal Arbitration Act in the form before this recent amendment was forcing these sexual assault and harassment claims into these confidential secret arbitrations. And, you can just think about what the implications are. One person had an issue and went to a secret arbitration, and that person's coworkers didn't know that there was a rotten apple at the company. The revision to the act that was passed in March is really a compromise. So it sort of sliced that particular issue where there seemed to be bipartisan and a lot of uniform agreement on that category of claims shouldn't be in arbitration. So that was what Congress decided to do, was to amend it more narrowly. What that may mean is that some of the momentum and thoughts on a broader arbitration reform may not have as much steam as it had earlier in the few years before that. Again, that is reading tea leaves is sometimes, as they say, what do they say about predictions? Predictions are hard, especially when you're talking about what happens in the future.
All right, so that covers that topic. We're going to now move into sort of practice pointers. We want to address this one district court case, which in and of itself is not, we're not suggesting this is sort of the new trend in the law, but it is indicative, I think, of a trend that's worth talking about. So this is a case in April of this year from the Northern District of California. It's Bielski versus Coinbase. And the specific issue we're going to talk about is there was a motion to compel arbitration filed by Coinbase, which is a cryptocurrency exchange, seeking to compel a claim brought by one of its users into arbitration based on standard terms and conditions, which included, I think, what most of the people who have dealt with these things would consider to be a standard language arbitration clause. But the court in this case analyzed it and found that a provision that is, I would say, not very uncommon,
right,
was actually deemed it to be unenforceable. So in this case, that provision was a pre-suit notice requirement. So it essentially said that before a Coinbase user can file an arbitration against Coinbase, it has to contact Coinbase's customer service, attempt to resolve the dispute, wait a certain period of time. And if you're unable to resolve it informally, then you are able to file an arbitration. But that provision was unilateral, it was one-sided. If Coinbase had a dispute with its customer that was subject to arbitration, it could file the day it accrued. And this is not an uncommon type of provision. We've seen it. Very common. And there are reasons that companies put it in there. But in this case, this judge in the Northern District of California said this is unfair, this is one-sided, this is unconscionable, and I'm going to deem this entire arbitration provision unenforceable. I'm going to deny the motion to compel arbitration, and your class action is live now in the Northern District of California. So this is an example of, we don't want to say that this is the new law or this is the prevailing view. It's one of the takeaways here. But an example of the type of scrutiny that courts are giving now to arbitration provisions, and we're going to talk a little bit more about this as we continue the program. But this was a this is a fixable provision. The fix is easy. Make it two-sided, make it mutual, right? Make it so that Coinbase and its user, or whatever company and whatever parties you want to put into the equation here, make it so that it is a two-sided mechanism that is fair to both sides. But we do think that this is an example of one of our key themes today, which is that you shouldn't just assume that the arbitration provision that you drafted 10 years ago and haven't looked at is still as enforceable now as it was 5 to 10 years ago.
Right. And I think, one of the big things that we wanted with this presentation is, I think of if it's a company, and again, it's if you're looking at arbitrations on consumer, or if you have, if you're a company that is a standard form commercial contract and it's for your dealings with other business partners, you're going to have a form contract. Don't think of your arbitration clause as well. Here's our corporate headquarters, and we put new carpeting down in 2010, and we're just going to leave it, and it's great. And we painted the outside of the building in 2011. We put a new arbitration clause in 2012. We planted trees in 2013, and these are all things we don't have to think about again. Arbitration is not like painting the floors or putting up new trees. It really is. Maybe the tree analogy is important. It is evergreen. The Supreme Court, five, really six if you count Allocate partners decisions this term. Cases like this where courts are doing kind of curious things. If you don't, you really need to think about it as a live document. And what happens that I've seen way too often is, companies just sort of drafted this a decade ago, didn't really, maybe copied somebody's arbitration clause. That happens a lot, and really didn't think about it critically. And now you may have an arbitration clause that hasn't been revised in 10 years, but the courts they're not stopping, and they're not going to say, well, you had that clause from 10 years ago and it would have worked 10 years ago, so no worries. So this is, that's one thought. And then the other thought is just really think about why do you have a provision in there, and, think critically about the particular provisions.
Right. And so now we're going to move into a big picture recent trend in arbitration that is a response to the prevalence of class actions being defeated in district court based on arbitration provisions. There's this thing, if you're on this Zoom or you're in the room, you've probably heard about this. This is the phenomenon of mass arbitrations. And Aaron, I'll turn it over to you to talk about this.
Yeah, and look, this is a topic that if I had 2 hours, I could probably talk for 2 hours about this, but I'll try to keep it simple, but it's interesting. So I'll give a bit of the history of this and how this has come about. Basically, the Supreme Court, and a lot gets back to the case I mentioned, AT&T versus Concepcion, that really started the U.S. Supreme Court pushing back on the idea that, or basically saying that you cannot override arbitration with a class action. So in other words, if you put the simple holding of Concepcion is, an arbitration can sort of defeat a class action. If you have an arbitration provision that you have to go to arbitration, you waive a class action. The Supreme Court said that was okay. And, there were a couple of cases that came after that. One's called American Express versus Italian Colors. And the Supreme Court basically, shot down the attempts to fight the Concepcion rule. So what happens? Well, some plaintiffs' lawyers, plaintiffs' class lawyers, and some very well-funded lawyers said, well, okay, you say we have to go to arbitration. Well, we're going to send our plaintiffs to arbitration, no problem. And how many plaintiffs do we have? Well, we've got tens of thousands in each case. So these mass arbitrations come up in these cases where, certain plaintiffs' lawyers who have been able to amass just very large rosters of clients have filed these what I call mass arbitrations. It's really mass filings of individual arbitrations. And what they have done is these come up particularly in cases where the defendant has an arbitration provision that says the defendant will be responsible for all of the fees and costs of the arbitration. And you say, why would a defendant who's concerned, maybe about a class action, this is more in consumer cases, really only in consumer cases, want to pay the whole freight of the arbitration? Well, the reason why is it all goes back to that AT&T versus Concepcion case. And in that case, sort of the industry was looking for, how do we get a case up to the Supreme Court where we could take all of the other objections by the wayside? So one of the historic objections for arbitration was, well, it's not fair to a plaintiff. A plaintiff, they go to state or federal court, their filing fee is going to be a few $100, and that's really going to be their main cost. But now if they go to arbitration, the filing fee for an arbitration may be a few $1,000s. And if you split the fees for the arbitrators, even in a single arbitrator case, it's going to be several thousand. And some arbitrations have 3 arbitrators. You could easily have arbitrations where just the fees for the arbitrators are tens, even hundreds of thousands of dollars. So the idea was, write an arbitration clause that makes it very fair to the plaintiff. The defendant will pay all the fees. In fact, I think the AT&T and Conception one said something like, if you win an arbitration, we're just going to double it. Everybody gets a car. We'll just double what you get. So it was, if you sort of wanted to sit in the lab and make an arbitration clause, it was as pro-consumer as possible. That was the AT&T versus Concepcion one. So it goes up, Supreme Court says in Concepcion, not a problem, class arbitration, or class waiver, I should say. Class arbitration is a whole different thing. So what started happening a few years ago, and a couple cases with, I think, Uber and a few others, some plaintiffs' lawyers who were pretty well funded started filing these bulk arbitrations. As I said, bulk individual filings of bulk arbitrations, and it does really create a problem for the defendants because now they're on the hook for all of the individual filing fees. There's a lot of commentary for what does this mean. I know there's a couple commentaries a few years ago. I think Amazon took out its arbitration clause. I think a lot of it remains to be seen on how much of this is it really throwing out the baby with the bathwater, or is this an issue that's confined to, a relatively small set of companies, who could have potential class actions against them that are hundreds of millions of dollars, if not more, of liability. The other thing that I'll say about this, that I do think some in the defense bar may not appreciate, it is extremely expensive and costly, well, that's redundant, for the plaintiff's lawyers looking for these consumers, these class members or clients. It's like Google AdWords and that type of stuff, where to find the people to sign up, it's not, the overwhelming majority of plaintiffs' class lawyers who file class actions, they file it typically on behalf of one person, maybe a couple of them, they may have also, I have 2 or 3 backup plaintiffs. The notion that every plaintiff's class lawyer is going to have thousands of backup plaintiffs, because to file these individual arbitrations, you actually have to have a client. You can't file an arbitration on behalf of somebody who's not your client. So it remains to be seen. I think it will, shake out in the next few years. I will say this, that some of the arbitration providers are trying to put rules in place that sort of respond to this. It's kind of like a full circle, where they're saying, well, if there are numerous arbitrations filed by, sometimes they'll say like the same lawyer on the same issue, there'll be individual arbitrations, but we could, consolidate them for like discovery purposes, not unlike like you would think of a federal MDL. So again, it's a new trend. My first comment is to companies who are thinking about putting arbitration clauses, but may have seen an article on Google about mass arbitration. So my first comment is don't panic. And my, second comment is let's see what happens in the next few years. But I'm not ready, this is where I give my personal opinion. I'm not ready to say that arbitration is, as a defense to class action is done with.
Right. And it's an interesting point that there is a major practical difference between finding 20,000 class members for notice for a class settlement and finding people to distribute settlement checks to,
Right.
versus signing up 1,000, 10,000 clients and filing individual arbitration. It's a problem of a different magnitude.
Right. And this isn't just like somebody clicking on you have to have a retainer agreement with them. They have to be your client. So it's been done a few times, but it's hard. So anyhow, we'll see what happens. I promise in 5 years, we'll do an update on mass arbitrations.
Stay tuned.
And I'll update the jokes.
Okay. So moving on, we're almost at the end here. This one goes sort of hand in glove with the mass arbitration issue. This is a practical tip. It's a question of how do you allocate the costs for the filing fees? As Aaron just said, after the AT&T versus Concepcion case, there was this rush to complying with the provision that was enforceable in that case and deciding that a respondent will cover all the filing fees. That's pro-consumer, it's more fair, it's more likely to be enforceable. However, the risk now is you have mass arbitrations and you could be on the hook for millions of dollars in contractually required filing fees. On the other hand, the risk of splitting the fees is this enforceable? Am I going to get kicked out? Am I going to lose my motion to compel arbitration because a judge in California or elsewhere says this is unfair? So one of the alternatives that we've discussed is tailoring the filing fee toward whatever the claimant would pay in the equivalent state court action. So as Aaron mentioned earlier, it could be perceived as unfair if filing this case in state court would cost a claimant $350, but filing it in arbitration under JAMS or AAA rules or whatever else would cost them $1,700. So one potential alternative is to specify in your arbitration agreement that the claimant will cover X amount of the filing fee, equivalent to whatever the filing fee would be in the state court or the federal court,
Right.
depending on the claim, right? And there's pros and cons of that. There's, I think, deterrent effects of that.
Yeah, and a couple things. So what Charles said, and I keep on talking about the AT&T versus Concepcion case, but it really was significant because that case came out, and if you looked on Google and arbitration, and I can absolutely tell you, I won't mention any names or whatever, but I know for sure that there were a lot of companies who literally what they did after the AT&T case came out, went on to AT&T's website and took their arbitration clause and cut and pasted it and made that their arbitration clause. So there may have been a lot of them. There's somebody did a study on this. I don't remember. And I said, how many of the arbitration clauses copied AT&T's clause? And it was dozens of them. So there wasn't a ton of thought. It doesn't make sense for a particular company. The other thing that this shifting, or at least putting the petitioner, the plaintiff, on the hook for a little bit of the fees, it's not just mass arbitrations. I can tell you, I talked to a lot of in-house counsel about this. It's a lot of it is just the pro se plaintiffs who have these esoteric, being polite, lawsuits that they just file them, and there's whatever they submit a 1-page form to the AAA, and they don't have to do anything else. And I've heard some in-house counsel tell me, look, if they had to pay even $100, I could tell you that I've got a portfolio of 50 of these cases, and I could tell you if some of these people had to pay $100 for a filing fee, they wouldn't have filed the case. So that's, again, I don't want to say you should put in $100 or $150, but it's just something to think about. So it's small claims court in Miami to file a case is where we are. Is I don't know, it's like $100, $80 or something. Is it under $100? I think it's up to. Miami has, I think it's all of Florida. It's a sliding scale of up to whatever, a few $1,000s, and you're only paying under $100 to file it. And I've looked at other states. It's all basically they're all pretty low. So that's just something to think about. That's a bit of a deterrent.
And then the last practical tip or issue we want to talk about also relates to how you draft your arbitration provisions or your employment agreements, your terms and conditions. And that's a question of, should you specify the governing law? And there's pros and cons to this. I think the default is yes, let's specify the governing law. Let's make it a law that we, as the company, are familiar with, maybe the law of where we are based, because the advantages of that include we know the law. It's easier for us to stay on top of it if there's any change that affects our business. We can predict the outcomes. And if we have a bunch of cases in this jurisdiction, we will have the opportunity to sort of develop this law to help ourselves over time. One of the cons here, and this is not a prevalent position, but I think this is why we think it's at least worth discussing, is that by specifying a governing law in terms and conditions or in an employment agreement, if you are a company that is, I don't want to say vulnerable, but may find itself facing a class action, a nationwide class action, if you specify the governing law, you may have eliminated a viable defense to certification. So let me explain that a little bit further, because the alternative that we were talking about is saying that the governing law for any claim, and imagine you're a national company with users, customers, consumers in all 50 states, is to specify that the governing law for any dispute between customer A and the company is the law of the state where the customer resides. Now imagine that multiplied by 20,000 class members, and you have from 50 states. And now from a class certification perspective, you have a defense that you're going to have individualized issues based on differing state laws for, large groups of the class members. And so is that going to apply to every company? Of course not. Is that going to outweigh the pros of specifying Florida law, New York law, whatever you want? It's a case-by-case decision, but this is the type of thing that we think companies should be thinking about.
Yeah, so and just think about it like you have a breach of contract claim, in a 50-state claim. You may have, again, there's not as much, there's a little bit of less of an arbitration issue, but it does matter because when you're drafting these terms and conditions, people put in arbitration clauses. Let's say you have an arbitration clause for whatever reason. Maybe you have like that judge in the Northern District of California that seems to find whatever reason to avoid an arbitration clause. So now you have a contract claim. Every state has different statute of limitations, right? Age of majority to consent to a contract. Who has to be in privity. So when you have these common law type claims, every state has all different kinds of nuances. And then what you have to do on class certification is go through the state variations and have to determine if those matter. But if you put in your terms and conditions, and they normally come in like the arbitration clause, that's why I see these issues as related. That's where you can sort of, you've perhaps unwittingly, you may have not thought of it, you've taken away what could be a defense. So that's something to think strongly about. Do we want to talk about the chicken and the egg?
Let's do it.
Okay. One of my favorite arbitration things is sort of what I call the chicken and egg problem. So one of really the issues where, I don't know, half the litigation, whatever it is, because of all the issues that we've talked about, the arbitrability question, as we said, most of those questions get delegated to the arbitrator, meaning the arbitrator determines if the claim falls within the arbitration agreement. Well, the one thing under the Federal Arbitration Act that the courts have to do, even if there's a delegation clause, is to determine if there is a valid agreement to arbitrate. That is called the contract formation question. And this comes up a lot, particularly with online terms and conditions, or companies that do business like the apps online, all that type of stuff. A lot of, the main defense on these online terms of service is the plaintiff says, online terms of service, you mean that little footer at the bottom? I never agreed to it. I didn't see that, or that is in tiny font, or your app was built that this, I wouldn't see that the terms of service. By the way, there's like, I could talk for 10 hours on how you should really build up your formation, your apps and whatever. I'm not a developer, but things that you should put in there. Yeah, and a lot of people don't, and that's why you have litigation. You even get to have a trial over it. But you put in, well, our contract shall be governed by Florida law. And now you go to court and you say, well, my terms and conditions were presented in a way that the plaintiff should have been on notice, and Florida law says so-and-so, and our contract says governed by Florida law. Well, what's the chicken and egg problem? The question is, do you have a contract? So people say, oh, we want to argue under Florida law because our contract has a Florida choice of law provision. But if you don't have a binding contract, you're not actually under what the choice of law in the contract says. So you have to go to the whatever the choice of law rule where the case is brought. So that's sort of an interesting thing to think about, that sometimes I see, and courts have overlooked that too, I think.
So here is our final thoughts slide. We've covered a lot of this already, I think, just a few slides ago. But one of our key takeaways, irrespective of all the Supreme Court decisions, is that these arbitration clauses should be considered living documents that need attention, even if it is just reading them once a year. If you're in-house counsel, take a spin through it, print it out, read it out. Stay on top of CLEs like this one. Be mindful that there are changes ongoing in the law. There are judges and courts around the country that have different opinions about how some of these provisions that we may consider to be set in stone, whether they really are, whether they should be. And so these are things that we think that companies should really be paying attention to, because the downside of having an arbitration clause deemed unenforceable can be significant. You may think that you have a defense to a problematic class action that evaporates because you didn't keep your arbitration clause up to date.
Yeah, no, absolutely. And by the way, again, it's not just for this, this isn't purely limited to the consumers and avoiding class actions. A lot of those, Charles, you and I had a case a few years ago where, we litigated, it was a commercial case, business to business case. And we litigated for a year in federal court over whether the case should be in arbitration or court. And then we went to an arbitration. So, and again, if the clause would have been a little cleaner in that one, that's something to think about. So again, not just on the consumer side, but really, it's, again, when we wrote the ideas for why we should do this, I think we said, don't think of arbitration clause as set it and forget it. I really absolutely would encourage anybody, whether you're in-house counsel or talking to your clients, to at least, if you haven't done it in a while, it's really sort of company health is something you really should think about. Why do you have it? Do you want to be in arbitration? And by the way, let's, detour a little bit. Just give some thought. If you're a company and this is our commercial contracts, think about if you actually want to be in arbitration. Challenge the assumption of, well, we want to be in arbitration because we want to be in arbitration. So think about if it is really something you want. I certainly have had in commercial settings, I've had clients tell me, maybe I don't want to do that. Maybe the benefits that I thought were with arbitration maybe aren't there. Maybe I'm not as concerned with confidentiality. Maybe I don't like the idea of being in a dispute where my ability to take discovery is handcuffed. And, maybe it's because I have to pay an arbitrator. It's not as cost effective. Maybe I don't want 3 arbitrators. Maybe just 1 arbitrator is fine. Maybe I'm comfortable having desk arbitration, meaning you decide the dispute on the papers. But just because you have an arbitration clause, just think about why you have it. And I think that's my theme too. That on the consumer side, it's different. The consumer side, you're putting in an arbitration clause. Let's be honest, the reason why companies put arbitration clauses in consumer contracts is because they want to avoid class actions. And if anybody tells you otherwise, tell them, no, that's just not true. Because if there's one thing that I'll take to the bank, that's that. And they'll say, oh, we want it because it's quick. No, they want it because they want to avoid class actions. That's consumer. Commercial's a little different. Commercial really think about why you have it in there. What's your purpose? Do we have any questions?
So now we're at the end of our presentation. We do not have any questions that have come in through the remote chat. If anybody has any, type them in quickly, and we will try to get to them. We're also open to questions from the live audience here in Miami. I don't see any hands up. So there's one. Okay.
Isn't also one of the reasons that you want an arbitration clause is what country, for instance, the dispute arises? You're in a country where the court system and the judicial system could be subject to challenge, let's say. It's better to have it there, whereas if you're in hopefully our country, it's not the same. And one of the things you're giving up, and the client needs to be aware of, is you're basically giving up your appellate rights.
Right. Yeah.
And that includes a mistake in fact and a mistake in law in most states.
Right. So I don't know how.
Repeat the question.
Yeah, I don't know if the volume picked it up. So Rick Roast, the head of our litigation department, asked a couple questions. Number one, what about, and I'm going to slightly rephrase your question, Rick. What about international disputes? This gets back to my commercial situation. Should you have arbitration, when you're in international disputes? And the short of it is that's a real consideration, that if you have a dispute with a company in, whatever country, one of the ideas why the ICDR and the whole concept of international arbitration really became prominent is because it does give a U.S. company who is going to do business with a foreign company, perhaps a foreign company based in a jurisdiction with a questionable, or however you want to call it, a different legal system is how I'll phrase that. Arbitration gives comfort, and that's really an important thing. The other thing, as Rick said, is when you are doing arbitration, again, leave aside the consumer stuff. The consumer stuff, the incentive for arbitration, as I said, is to avoid class actions. In commercial cases, it would be the same in a consumer, but in any arbitration case, you are really, really limiting your right to an appeal. If the arbitrator gets the law wrong, sorry. If the arbitrator, makes a mistake over whatever, sorry. Really, what you could appeal in arbitration is like if the arbitrator took a bribe. And by the way, even then it's kind of hard to even, prove that, how much you can say. Some cases, yeah, he took a bribe and it made a difference. But you really, really have a very, very limited scope of what can be appealed in arbitration. As I tell people, if you're going to go to arbitration, just assume you're not going to be able to appeal anything. And when I say appeal, I don't mean appeal, to the, circuit court, or, if we're in Florida, to the district court of appeal. I mean, to the trial court. So let's, take a life of a case. I'm Acme Company and Charles is Fun Time LLC. I sue him. We have an arbitration clause. I sue him in Miami-Dade's circuit court, the trial court here. The court says, no, go to arbitration. We have an arbitration and I lose. And I think the judge just totally got the law wrong, allowed all kinds of damages that weren't proximately caused. And I am so charged up and I want to appeal. And now I go, okay, and I go and I challenge and I go to the trial court. So that's when I say appeal. I'm quote unquote appealing the arbitrator's award, but I'm just going to a trial court, and the trial court says, huh? Did he bribe the arbitrator? Well, if he didn't bribe the arbitrator, there's not much that you could appeal. I mean, maybe did he conduct a hearing and maybe you told him, well, I can't be there Wednesday, and the arbitrator said, no, I'm having the hearing on Wednesday. Maybe that you could challenge. But there's not a whole lot that you could challenge. So that's an important thing. Now, and some people think that's good. Did you get it done theoretically faster? Although I've had arbitrations that a lot of time and a lot of, who knows? So that's something that's very important to think about.
Okay. Any other questions? I don't see any remote. Anybody else in the room? No? Okay, well, that concludes our presentation. If you have any follow-up questions, Aaron and I are pretty easy to find on the Carlton Fields website. We appreciate everybody who joined us here live, and we thank everybody who joined us remotely. And like Aaron said, stay tuned. We'll do another one of these no later than 5 years from now.
All right. Thank you, everybody.
Thanks, everybody.